Ladies and gentlemen, may I all welcome you here at the inaugural lecture of Dr. Oswald Jansen, appointed as Professor of European Administrative Law and Public Administration in the Faculty of Law. By giving this inaugural lecture, Dr. Oswald Jansen will accept this position, and the title of his lecture is Administrative Law and its Territory. Dr. Jansen.
Dear Sir Rector Magnificus, Madam Dean, dear colleagues, ladies and gentlemen. On the 1st of February 2016, the OECD published a report on one of the metropolitan areas in the Netherlands, the metropolitan region of Rotterdam-The Hague. This region is a bottom-up cooperation of 23 municipalities in southern Randstad region around the cities of Rotterdam and The Hague. It was formed out of the previous city regions of Rotterdam and The Hague. Cities and agglomerations are important economic engines. Large agglomerations are key players of transnational flows and act as essential spatial nodes in the global economy. According to OECD research, spatial structure is a source for economic strength. The Netherlands could get more of its cities, and this applies even more to the metropolitan area around Rotterdam and The Hague. Referring to economic theory of agglomeration economies, the OECD puts forward that the economies of the Rotterdam region and the The Hague region should be integrated more to increase agglomeration benefits in order to gain economic strength. Both the OECD and the European Union approach urban areas as functional areas. The definition of territory for determining administrative boundaries is arbitrary and often does not correspond with real patterns of life, job markets, and business flows. According to the OECD, policies for infrastructure, transportation, housing, schools, culture, and recreation are more likely to be complementary when they target functional areas rather than administrative borders. Therefore, functional urban areas are identified on the territory of all OECD member states in order to be able to measure metropolitan areas, to compare economic activity, and to better focus policies. According to specialists in spatial planning, the metropolitan region of Rotterdam-The Hague should be considered a soft space, which is a non-statutory, informal planning space existing alongside but separate to the spaces and scales of elected government bodies such as local, regional, and national government. Apparently, this is the result of a major proliferation of new territorial governance forms during the past 30 years. These soft spaces emerge on a range of scales: European, macro-regional, sub-national regional, metropolitan city regional, and on the local level. Some of these soft spaces go beyond borders, cross-border soft spaces. In order to organize the necessary administrative power, the challenge here is to find the right scale of subnational public administration by upscaling, the merging of municipalities, for example, or transscaling, for example, cooperation between municipalities. Both upscaling and transscaling meet democratic challenges, while upscaling hinders voice and accountability, as administrative power and representation are situated further from the citizen, and larger municipalities will distance the citizens from the decision-making process. Transscaling makes it difficult to distinguish responsibilities, reducing accountability and democratic legitimacy. In its opinion of the metropolitan region of Rotterdam-The Hague, the OECD addresses the choice of scale as well. In the future, the territory of the metropolitan area should be expanded south with Drechtstede and north with Leiden and its surrounding municipalities. The region should get more responsibilities and competences as well, such as regional economic development, spatial planning, and probably social housing. The OECD sees this as a long-term evolution because of reform fatigue following a series of territorial reforms or attempted reforms of public administration in the Netherlands. On the 18th of February, Benjamin Barber and the Mayor of The Hague announced that the Global Parliament of Mayors will convene in The Hague. According to Barber, such a World Assembly of Cities would give formal institutional expression to the informal cooperative networks and collaborative arrangements that have for years been making a significant difference in addressing the challenges of an ever more interdependent world. The involvement of cities would fill the democratic deficit resulting from globalization. The example of the metropolitan region of Rotterdam-The Hague touches upon regional governance and the issue of subnational scaling. The ideas of Benjamin Barber involve issues of global governance and supranational scaling. The development on global scale are a challenge to both international and administrative law scholarship. Administrative action is traditionally thought to be linked with territory. Administrative authorities' powers are territory bound. Nation states exercise authority on their own territory, which is jurisdiction. Subnationally, administrative power is distributed among territorial units such as municipalities, provinces, and regions. EU territory is derived from the territory of its member states. We have heard Mrs. Le Bon on that subject today. On the EU level, it's a matter of shared sovereignty and shared governance. First, I would like to discuss a few possibilities to bridge the gap between territory of public administration and the needed scale of administrative power. Here, I will discuss three themes: the custom-made territorial decentralization, cross-border cooperation between subnational authorities, and the expansion of the territorial reach of administrative law. In the second part, I will discuss themes that challenge the territorial base of administrative law: territory with multiple legal orders, internationalized territory or international territorial administration, and administrative law without territory. First, custom-made territorial decentralization. There are many differences in the way European countries organize their public administration. As far as territorial bodies are concerned, European countries, as a rule, have a two-tier local government system below the central, national or federal level. The same image applies to most OECD member states. The system in the Netherlands of municipalities and provinces is similar. France, on the other hand, is an important example of a three-tier local government system after creating région as the third territorial body in 1982. Mergers of local authorities, upscaling, or cooperation, transscaling, between them limit the mismatch between administrative boundaries and the scale of administrative power needed. In the Netherlands, the decentralization of tasks to municipalities has increased the need for a bigger scale of public administration. Nemelman, present, I saw all the way in the back, prefers upscaling above transscaling. Nemelman is of a similar opinion as the OECD. Transscaling increases administrative confusion and it is difficult to distinguish responsibilities. This reduces accountability and democratic legitimacy. And according to him, the current number of municipalities is evidently too high, and he refers to research from administrative scientists. The Netherlands currently has 390 municipalities and 12 provinces, the two images left above this sheet. The three other images are maps, are divisions of the Netherlands for statistical purposes and statistical purposes only. You will see 4 NUTS 1 regions, 52 COROP plus regions, and 40 NUTS 3 regions. NUTS is a common classification of territorial units for statistics on the basis of an EU regulation, and COROP is a Dutch territorial unit for the same purposes. Except for the creation of a new province, Flevoland, in 1986, the number of provinces hasn't changed since the 19th century. The number of municipalities has dropped significantly though. In 1900, the Netherlands had 1,121 municipalities. Between 2000 and 2016, the number of municipalities has decreased already with 147. The expansion of municipalities in relation the expansion of municipalities and the unchanged size of provinces illustrates the subnational squeeze. It has proven not to be easy to change the situation though. The most recent results of more than 50 years of discussions and proposals to reform public administration at the mid-level is the failure of the merger of 12 provinces into 5 regions and the withdrawal of the legislation which had created 8 obligatory city regions. The foundation of the government's argument to withdraw these city regions is weak and hinges on circular reasoning. The government wanted to put an end to this kind of intermunicipality collaboration despite a positive evaluative assessment. The aim was to end this form of public administration, which was originally intended to be temporarily because the desired end result would not be achieved. After all, this end result, which was the idea of city regions, was contrary to the desired two-tiered system. The end result is that agglomerations and urban areas are thrown back to voluntary forms of collaboration that already had proven not to work in the past. We will have to wait for yet another inevitable counter-movement. Leaving the creation of and the abolishment again aside of the agglomeration Eindhoven and the public body Rijnmond, the governmental ideas shifted from the creation of 44 districts with democratic representation between municipalities and 5 provinces, via the scaling down of the 12 provinces to 25 provinces, with executive tasks next to planning and coordination tasks, until the attempt to create a few regional authorities on agglomeration level. The last attempt started with the enactment of the Framework Act on Public Administration in Transition. This act created 7 collaborative regions on the basis of the Joint Regulations Act. The collaboration between municipalities within that region was compulsory. These regions were entrusted with powers from the local, provincial, and central level. The idea was that these regions would gradually evolve into the elected regional authorities. The withdrawn 8 city regions I just mentioned were the last remains of this intended reform. In this litany of good intentions, I should mention the failed attempts to create the city provinces of Rotterdam, Amsterdam, and Haaglanden. Rotterdam even had 2 failed attempts to create a province. As the example of the metropolitan region of Rotterdam-The Hague shows, the governance of metropolitan areas in the Netherlands is a challenge. At this moment, only voluntarily bottom-up cooperation agreements are possible, mostly on the basis of the Joint Regulations Act. In many European countries, the development of metropolitan regions created a coordination problem at the intermediate levels of government, the subnational squeeze I mentioned before. In the Netherlands, this is the case with both the metropolitan areas, the one around Rotterdam-The Hague and the one in Amsterdam. Although it's possible to transfer the necessary powers from all levels to a public body created entirely voluntarily on the basis of cooperation between the municipalities involved, history shows that it's difficult and time-consuming to arrive at enough consensus among many stakeholders to make this possible without direction from the central level or the legislature. There are interesting other solutions available to limit the number of tiers, though. For example, the recent reforms in the subnational institutional systems of France and Italy. With a few acts, France has created 14 inter-municipal métropoles and limited the number of regions to 12. I will not discuss the département. These établissements publics de coopération intercommunale are assigned tasks from 3 tiers: commune, département, and région. In other words, the French reform resulted in an important functional and vertical integration of 3 subnational levels of government, which is similar to the German county-free cities, kreisfreie Städte, English unitary authorities, and capitals such as Stockholm. After 2 decades of deadlock and some constitutional difficulties, Italy created 14 città metropolitana on the 1st of January 2015. These metropolitan cities consist of municipalities. The metropolitan mayor, who is the mayor of the chief town, heads them. The legislative body consists of members that are indirectly chosen by the city councils of each municipality. The città metropolitana are reminiscent of the French communauté urbaine. The main functions of these città metropolitana are local planning and zoning, the provision of local police services, transport, and city services. Back to the Netherlands. According to the Dutch constitution, the Dutch territory should have municipalities and provinces. The constitution does not prohibit the creation of new territorial public bodies next to municipalities and provinces. The creation of territorial public bodies instead of municipalities and provinces, such as, for example, municipality-free provinces or province-free municipalities, or a municipality and province-free territorial authority sui generis is unconstitutional though. In 1995 and 2010, two important Dutch advisory councils have stated the obvious. It is inevitable to scale up provinces, and in the end, in this internationalized and Europeanized world, a country as small as the Netherlands could do with one tile less. At the same time, the traditional one-size-fits-all governance approach to all parts of the Netherlands should be abandoned. Dutch public administration needs two metropolitan regions, Rotterdam, The Hague and Amsterdam. And next to this, a few smaller city regions. This would lead to a public administration that is more custom-made. It consists of different territorial bodies, the metropolitan region, city regions, municipalities and provinces. This should not lead to more tiers though. The metropolitan region could be province-free, the city region could, for example, be municipality-free, and at the same time, the gradual process of amalgamation of municipalities will continue. The Dutch constitution needs to be changed to make this custom-made public administration possible. The custom-made approach would lead to a better coverage of spaces by administrative authority where such power is needed. A smart choice of the space to be involved in the authority's territory and a custom-made attribution of powers, preventing the doubling of tasks, would do the rest. Hard spaces, so to say, would recover some territory from soft spaces again. Here, administrative law approaches can have a useful role. For example, at choosing their policies, administrative authorities have to consider each other's positions, which could be part of the principle of due care. The EU principle of loyal cooperation already had some national parallel effect. One could imagine an involvement in Dutch administrative law of the development of a general principle obliging administrative authorities to cooperate loyally with each other. Both the amalgamation of municipalities and the creation of authorities such as the metropolitan or city region will distance the citizens from the decision-making process, even if the democratic legitimation is secured by representation at a greater distance. Identity and proximity problems could be addressed by arranging a smart sub-municipal structure and by using smart participatory techniques at decision-making. This would be in line with one of the assignments of administrative authorities and administrative law, as set forth by Peter Linset already, which is the provision of democracy. I switch to cross-border cooperation. Several legal orders acknowledge obligations of administrative authorities to cooperate. Important national examples can be found in France, Germany, and Spain. The principle of loyal cooperation is one of the most important general principles of European administrative law. It is also known in global regimes and other treaties, such as the UN Charter and the agreement establishing the World Trade Organization, and its international environmental law all over. According to the principle of national institutional autonomy, the European Union shall respect the structure of the public administration of its member states. At the same time, according to the principle of loyal cooperation or the principle of union administrative loyalty, administrative authorities within the European Union are obliged to cooperate loyally. The European Union is paved with networks between all kinds of administrative authorities from both EU member states and the European level. These networks form the horizontal and vertical relations to cooperate in order to effectively enforce European law. An increasing diversity of offices, bodies, and agencies is now part of this European composite administration. Similar networking exists between national agencies and independent authorities, as well as European agencies in global networks. They engage in different kinds of agreements in order to coordinate their activities. and these administrative agreements should be distinguished from international agreements and treaties according to the two Vienna Conventions on the law of treaties. These administrative agreements have a long history in the practice of international cooperation. Despite their long and widespread use, these administrative agreements are understudied, as a recent PhD here at the university showed. As far as network agreements between subnational local authorities are concerned, they seem to be quite common as well. Above, we discussed joint regulations, which are agreements between public bodies such as municipalities, provinces, and water boards in the Netherlands. Similar agreements exist in Germany, Zweckverband, Verwaltungsgemeinschaften, and France, Länderkommunalität. In the US, these agreements are called compacts, and they are common as well. What if these kinds of agreements are concluded between local authorities on each side of the national border? As we have seen before, public administration needs to organize administrative power outside administrative boundaries. A functional area regularly transcends national borders. There is a need for local authorities to cooperate with each other on both sides of the border. National governments have always been reluctant to support transboundary cooperation. Foreign policy is considered to be an exclusive competence of the central level of the state. The French Code on Local Territorial Communities prohibits engaging in an agreement with a foreign state unless this is a European grouping of territorial cooperation or a Euro-regional cooperation grouping, EGTC, ECG. The aim of EGTC, Jean-Bernard Roby already mentioned it today, is cross-border, transnational and interregional cooperation between its members with the aim of strengthening the economic, social and territorial cohesion of the European Union. The EGCT is restricted to the territory of the European Union, but administrative authorities located on the territory of third countries adjacent to member states can access an EGCT as well. An EGCT has legal personality and the law of one of the member states will be applicable, according to the theory. Local, regional, as well as national administrative authorities can be member of an EGTC. An ECG, which is a Council of Europe instrument, unlike the EGCT, which is a European Union instrument, could be a possibility outside the territory of the European Union. Although not many countries have signed the relevant protocol and even less have ratified. It should be noted that unlike similar national forms of public cooperation on each side of the border, it is not possible to transfer regulatory powers to an EGCT. Also, the tasks can be transferred, that can be transferred to this public body are limited. The establishment of an EGCT is complicated as well because of the involvement of the central level of the state, of the European Union and a few others, next to the regular partners. By the way, the cooperation here around Maastricht, the European Union region Maas-Rijn, is not an EGCT or ECG. It is a foundation under Dutch law, Dutch civil law, and is based in Belgium. The border region Charlemagne, which is a bit more north, does not have legal personality as far as I can see at all. Whereas the EU region, Rijn-Maas-Noord, has legal personality under German law, Zweckverband, which is according to the Anhalt Treaty between Germany and the Netherlands. All in all, this is a very complicated image which illustrates the difficulties to find the legal construction to organize administrative power on regions at the border. As Otto Meyer has put it in 1869, Unsere Staatsgewalt beansprucht nicht, die Staatsgewalt zu sein für die ganze Welt. This limits extraterritoriality in a very short sentence. According to the principle of territoriality, administrative authority is thought to be related as well as limited to territory. This applies to the execution of administrative powers by subnational authorities, national authorities, and EU authorities. In Dutch administrative law scholarship, only older works briefly discuss the subnational territoriality principle. In Dutch case law, just a few explicit referrals to the principle of territoriality are available. Territorial bodies, such as municipalities and provinces, do not have extraterritorial legislative competence. The municipality, as an example, which prescribes sanctions on infringements not only of rules of firefighting on its own territory, but also on the territory of neighboring municipalities, acts outside its powers. The same applies to municipalities or even on the sometimes the territoriality principle touches upon mistakes resulting from the change of the attribution of territory from one province to the other. And the same applies when these changes occur in the territory of municipalities. This means that according to Dutch law, local authorities do not have the possibility to extend their rules to beyond their territory. There is some Dutch case law on the application of the territoriality principle limiting the powers of national authorities as well. An interesting example involves Baarle-Hertog, which is a Belgian enclave surrounded by Dutch territory, or more precisely, 30 enclaves of Belgian territory on Dutch soil. The local broadcasting foundation applied for a permit to use a certain frequency. According to the Dutch Trade and Industry Appeals Tribunal, this was the execution of an administrative power on Belgian territory, and therefore the Dutch authorities lacked competence. In a decision of 2013, the same court ruled that the territoriality principle does not need to be explicit in legislation to have a limiting effect on the execution of administrative powers. This resembles the approach according to the presumption against extraterritoriality in the US. It's a major public law challenge to regulate activities by people and companies that find their playing field more and more on a supranational level, which is not only European or regional, but even global. Globalization has posed challenges to the effectiveness of the territoriality-based system according to which each state regulates activities with its own territory. US and EU regulators regulate certain activities abroad that generate effect on their territories. This territorial extension or extraterritoriality could be a breach of customary international law. Disputes with other countries are avoided with agreements between administrative authorities of both countries, of both systems. I can only give one example, but other examples can be found in competition law, financial law, and environmental law. And the example was already mentioned today, the Data Protection Directive. It has a broad territorial scope in order to prevent individuals from being deprived of the protection guaranteed by this directive and to prevent that protection from being circumvented, as the Court of Justice considered in the Google Spain case. If third countries offer an adequate protection, it is possible to transfer personal data to that country. Member states, as well as the European Commission, may find that a third country ensures an adequate level of protection. This gives room to agreements and negotiations with third countries, ensuring a certain standard outside the territory. In the Schrems case, one of the lawyers is present, the ECJ decided that at that time. decided that at that time the US did not have the adequate level of protection. Now I proceed to the part where I challenge territory. Territory with multiple legal orders. On the territory of international cities, such as The Hague International City of Peace and Justice, Brussels, New York, there are many buildings that enjoy immunity. Main examples include embassies and the offices of international organizations. According to the Vienna Convention on Diplomatic Relations, the premises of a mission as well as diplomatic agents shall be inviolable. And the host state is under the obligation to protect these premises and to duly respect diplomatic agents. At the same time, it's the duty of all persons enjoying these privileges and immunities to respect the laws and regulations of the host state. The territory of embassies and international organizations remain the territory of the host state. Immunity does not imply that national administrative law is not applicable on the territory of the offices of the embassies or international organizations. This is often explicitly stipulated in headquarter or seat agreements of international organizations, such as, for example, Eurojust and the International Criminal Court. It also applies to, for example, the UN headquarters district in New York. Hence, administrative law, regulation of building activities, environmental rules, rules on fire safety, the disposal of waste, working conditions, certain working conditions apply. This also means that subnational, local administrative authorities are the competent authorities. They give the necessary permits upon application and execute inspections on the fire safety of the premises. At the same time, international organizations are given civil law legal personality according to the host state's law. This means that agreements are possible about both civil and administrative law issues. In practice, administrative agreements between international organizations and subnational administrative authorities seem to be quite common. It is my impression that the form of a non-binding memorandum of understanding is preferred here. The international organizations have their own legal orders. Some of them fall within the UN or EU legal order. Many have their own legal order. Imagine that these legal orders are seated in one area, locally, and agreements have to be made between them on certain local issues. The legal complexity is a real challenge here. This is Villa Kabila, which used to be the mission of the Democratic Republic of Congo in the Netherlands until the middle of 2009. After that, the diplomatic representation was moved to Brussels. A bit later, squatters occupied the building and it became known as Villa Kabila. On the request of a Lebanese acting on the basis of a decision of a DRC court, the premises were seized. This led to an interesting decision by the Supreme Council. In line with earlier case law, the Supreme Court held that according to the current understanding of international law, immunity from execution is not absolute. State property cannot be subject to coercive execution. According to international customary law, the immunity not only applies to premises that are in use, but also to premises intended for use by a state for governmental purposes. This means that administrative law sanctions cannot be executed on premises used or intended to be used by diplomatic missions for governmental purposes. This illustrates that immunity of embassies, international organizations and privileged people complicates law enforcement of the home state's administrative law. This even is a legal reason to tolerate infringements. Dutch administrative authorities have a duty to enforce the law, especially when interested third parties explicitly apply for enforcement measures against an infringement. The duty is quite strong. According to the Council of State, the City of The Hague could refuse to impose the administrative sanctions against a garage that was built against regulations, referring to the impossibility to enforce the sanctions that were to be imposed. Law enforcement was requested here by the neighborhood of the embassy involved. I should add here that the municipality's decision not only included the refusal to enforce the building regulation, but also to explicitly tolerate the infringement temporarily and on a few conditions. According to this decision, the illegal situation would be tolerated during the time that the garage is used by the embassy. This decision was also noted in the land register to inform possible future owners of the building. There also was an agreement, here we are again, an agreement between the embassy and the municipality authorities that the site on the garage would be covered with planting to improve the outlook. The agreement was part of the administrative decision to tolerate. Ladies and gentlemen, what is the best way to find out how immunity works at the imposition of administrative fines? One of our colleagues present knows the answer, but he will not give it. I will do that. Indeed, that is to impose a sanction on a judge of the International Court of Justice. So we did. And he or she was driving 13 kilometers per hour too fast in Wassenaar, and I should add that it was Wassenaar. Judges of international courts have the same privileges and immunities as heads of state of mission. Following an instruction of the Dutch Ministry of Foreign Affairs, the public prosecutor argued that immunity only applied to coercive measures to execute administrative fines. However, the court decided that this immunity also applies to the mere imposition of administrative fines and squashed the administrative decision imposing it. I will now turn to international territorial administration, which is the exercise of administering authority, executive, legislative, or judicial authority by an international entity for the benefit of a territory that is temporarily placed under international supervision or assistance for a communitarian purpose. It's the alternative for occupation, and it plays an important role in peacemaking. International territorial administration replaces domestic administrative authorities and administrative actors, and it disconnects the notion of governance from the concept of sovereign state. International territorial administration is used as an instrument to contribute to the solution of territorial disputes. By now, international territorial administration is less preoccupied with classical standards of civilization, such as ending cannibalism and slavery, and more with good governance, rule of law, and capacity building. In international territorial administration, international governing institutions are not only in charge of restoring law and order, but they also execute legislative and executive powers. They rebuild and supervise the functioning of the domestic legal system and appoint or dismiss public officials. International territorial administration is an example to illustrate the inaccuracy of the description of international law as norms by nation states and law among nation states. Here, international law directly affects individuals. To what extent domestic and international governance institutions are subject to comparable democratic and procedural rule of law requirements in the exercise of their powers? International institutions involved in international territorial administration enjoy privileges and immunities, and they are subordinate to their own laws and principles. Their administrative actions are not governed by standards of domestic law, although they are surrogate administrative authorities. International organizations have not been willing to accept a right of individuals to obtain review of administrative actions before courts or other independent bodies with greater powers than ombudsmen. As transnational entities exercising international public authority and as direct holders of domestic authority, they should ensure and respect democratic rights and freedoms, and they should act in conformity with procedural rule of law principles such as fairness, transparency, etc. Institutional checks and balances and mechanisms of public participation should be there. The right to access to a court may oblige international organizations to provide for independent bodies to deal with the legal protection of individuals. The last subject of today, administrative law without territory. International law scholarship has identified a trend called deterritorialization. We had a very nice talk of Daniel Ortiz on that subject, which is the detachment of regulatory authority from a specific territory. The term is taken from social sciences, where it means the detachment of social and cultural practices from specific places. International lawmaking is more and more in the hands of norm-setting authorities that are attached to the issue area at stake and less linked to territoriality. This raises issues of democratic legitimacy, for example. On the global level, there are many global regulatory systems and global institutions. In 2011, 64,442 international organizations existed and only 193 nation states. This already shows that the nation state is no longer the exclusive source of public power or administrative action. According to some, this is the end of the nation state. In fact, there is growing consensus among public law scholars that it is meaningful to discuss public law beyond the Westphalian nation state. Post-national public law, sometimes they call it. Some even use the wording of the end of the state or similar. Others, such as Teubner, identify trends of constitutionalism beyond the nation state and apply network theory on international law. And in her known book, entitled A New World Order, Anne-Marie Slaughter points at the phenomenon that more and more social and economic networks operate at the global level, and this applies increasingly to governments. According to Slaughter, participants in the discussion on globalization have routinely focused on two major shifts, from national to global and from government to governance. But the shift from unitary state to the disaggregated state has drawn far less attention, according to her. And according to her, a new world order based on government networks working alongside and even in place of more traditional international institutions holds great potential. Here, she refers to the EU experience with regulation by networks. And indeed, the European networks are very dense, and the mix of horizontal and vertical links form, as I said before, a European composite administration. The concept of composite administration could also serve the analysis on the global level, the international composite administration. These global regimes regulate almost every human activity. It covers fields such as forest preservation, fishing, water regulation, environmental protection, coffee, pharmaceuticals, intellectual property, refugee protection, etc., etc., etc. I took the list from Sabino Cassese. These developments have led to the emergence of global administrative law, according to Kingsbury, Krish, and Stewart in their famous contribution. They identified an important accountability deficit in the growing exercise of transnational regulatory power, which has led to two responses: extending the territorial reach of administrative rules, which I discussed before, and the development of new administrative law mechanisms. Global administrative law is much more than law incorporated in treaties and cooperation between nation states in international organizations. It also involves the activities of subnational state actors such as regions, cities, independent and other administrative authorities, as well as non-state actors such as NGOs and transnational companies. The administrative law without the state and even without territory or deterritorialized still, after 10 years of global administrative law scholarship, offers a great challenge to administrative law scholarship. It requires joint efforts of specialists in international law and European administrative law and constitutional law, European law, and probably private law to continue to analyze developments in all different kinds of networks and legal orders. Maybe, you should have an aim in life, it will be possible to develop model rules based upon an analysis of existing standards and practices that are firmly based upon a generally accepted set of values and principles of global or international administrative law. At the same time, it is important for legal scholarship to develop mechanisms of legal protection that clarify the position of national administrative authorities and courts and supranational authorities and courts to guarantee these values and principles in international law. Conclusions. The territorial limits of administrative authorities do not always cover the space where administrative power should be organized. Most of the time, it is other disciplines such as economics, administrative sciences, urban and rural planning that determine functional areas, which helps to focus policies. The lawyer creates the legal constructions to bundle governance and the legal instruments for use by public authorities. They have to work with them. From the point of view of a public law specialist, this is a continuous dynamic process consisting of a few elements. I'll just name three. A firm and steady system of administrative authorities and public bodies covering the territory, a more flexible shell of cooperation instruments such as private and or public law agreements and civil law entities, and a set of legal rules and principles regulating their interplay and bridging the gaps. And although big changes in other parts of public administration were achieved as a result of the policy of compact government in the Netherlands, they did not achieve to reform the territorial scaling at regional level. I believe the egalitarian one-size-fits-all two-tier approach ignores the great differences between areas in this country. It's time to develop an approach that recognizes the differences between metropolitan areas, rural areas, agglomerations, and city regions. We need to change the Dutch constitution as well. As far as legal constructions are involved to facilitate transporter cooperation between subnational authorities, difficulties arise. Administrative law and international law scholarship should combine forces more and pay attention to the phenomenon of binding administrative agreements between subnational administrative authorities next to treaties and similar international agreements. As we have seen, they play an important role in the transnational networking and cooperation on both the European and global level between local administrative authorities and agencies, and even on the local territory of international cities. The importance of this increased attention is also illustrated by the development of more and more legislative techniques to extend the territorial reach of standards and legal rules in order to globalize those standards and rules. In fields like competition law, environmental law, privacy regulation, financial services, conflicts of these kinds of extraterritorial reaching rules are prevented in a more procedural way with agreements between the competent authorities involved. The exact constitutional, administrative, and international law legal status of these kinds of administrative agreements needs clarification. Global actors cannot turn their back on values such as democracy, rule of law, accountability, transparency, and due process. According to some, international law is immature in this respect. The tension between immunity of international organizations and legal protection of individuals clearly shows the problem. Administrative authorities and other standard-setting authorities should respect these values. They should check whether their decision-making process meet these standards. And if they don't, they should face the risk of less effective standard setting due to non-acceptance and nasty, lengthy and widespread litigation. We need this mechanism. The accountability gap on a global level should not only be bridged by national and international courts, though, but also by national and international administrative authorities. This counterbalancing network is needed to develop values and principles on a global level. I would like to conclude with some words of gratitude. First of all, I would like to express my gratitude to the Executive Board, the Board of Deans, the Board of the Stichting Wetenschapsbeoefening, and the Law Faculty of Maastricht University for the confidence they expressed with the decision to appoint me in this position. After finishing law school in Nijmegen, my career covered Amsterdam, Utrecht, Den Bosch, Den Haag, and now Maastricht. I try. Nijmegen and Amsterdam are connected with the directors of my PhD thesis, Geert Korstens and Willem Konijnenbelt. It's a privilege and a pleasure to be a member of the circle of Geert Korstens, consisting of all his promotee. It is a privilege to continue to have meetings with Geert Korstens and with Willem Konijnenbelt. I can always exchange ideas with them and learn from them. With Willem Konijnenbelt, I had meetings in France. We have contact about the quality of local legislation and actually on administrative law in general. John Vervalle, present as well. Rob Widdershoven, I saw him on the street somewhere. Probably smoking a cigarette. Mark my path to specialize further and discover new territory in Utrecht. Administrative sanctions, legal comparative research, and European administrative law. Philip Langbroek and Gerda Jurgens marked the years of collaboration in teaching in Utrecht. The yearly Christmas dinners marked the close contact I still have with many former colleagues of Utrecht. Much less regularly, but still, we find each other in our regular pub. They still know what I want to drink. And I'm sure this will continue for the years to come. Elise Steiger played an important role in my first steps as an attorney in Den Bosch. I retain good memories of the fraternal atmosphere during my time at that law firm. Janneke Blok marks my shift to the city of The Hague, and she gave me lots of space to discover my role in this new position. And then I had to switch Jan. I changed from Jan van Heiningen to Jan Sauvage Nolting as supervisor, as a lawyer. I'm happy to have met collega, the colleague, Peter van Toor, to share work experiences as a civil servant with. And finally, Chris Bakkes. What can I say? You went back to Utrecht just before my inaugural speech. I came from there, you went there. I'm grateful that you offered me this opportunity. And then again, Utrecht is not at the end of the world, and I'm looking forward to work together with your successor. Aalt Willem Heringa, Ellen Hardy, Sophie Polainus, dear colleagues of Maastricht, I'm here now for about a year, and I'm thankful for the way I was received in your midst. Sander, finally, Jansen and Jansen, namesakes in one section. Richard, Mariska, I am proud to be your father. Camilla, I'm happy that you are such an important part of my life. And Anja, there's so much I'm grateful for. Let us stop taking days off to work and enjoy life. Now we can and we will. Ik heb gezegd. well.
Professor Jansen, let me also, on behalf of the Executive Board, congratulate you with this new position here in Maastricht. Let me also congratulate the Dean of the Faculty of Law with having succeeded in attracting somebody else from The Hague to here, where, of course, here you will deal with the real issues of global law, but also cross-border law, etc. As probably the only non-lawyer in your midst here, it reminds me already of a couple of decades when we discussed the Avantis industrial field, where we were discussing German and Dutch law with respect to construction, various other rules and regulations. And the whole idea of an EGTC was then also one of the issues which, in the end, did not lead to any kind of results, as you have just also illustrated here in this talk. But of course, I'm an economist, and economists have to figure out that lawyers finally decide everything. Ladies and gentlemen, let me also thank you all for being here, and you have the opportunity to congratulate our new professor at the reception, which will be held in the rafter outside. I close this session. Thank you.